And please let me know as soon as you have started to record.
Thank you.
Yeah, it says, yeah, it's confirmed to the site. Good morning, everyone, and welcome to the discussion class for the Law of Delict 2022. Ladies and gentlemen, I think I should first start by introducing myself. For those who do not know me already, my name is Machilane Mokotong. I'm one of the lecturers, or rather professors, responsible for the Law of Delict. I am not alone. As usual, I am with my colleague, Professor Johan Knobbe, who will be presenting for us this morning. In assignment 1, the student will be examined on the 2 of the 5 elements of delictual liability, namely conduct and wrongfulness. We are very concerned lecturers for your success, and we want you to do well with the assignment. We thought it to be proper to have a discussion pertaining specifically to the 2 essential elements that I've already mentioned. Therefore, the purpose of this discussion is to introduce you to the elements of conduct as well as the element of wrongfulness. We assure you that by the end of this discussion, you will be very familiar with these 2 concepts. Before I allow Professor Knobbe, our presenter, to take over, I would like to mention to you that we have muted all the students due to the disruptions that we had with our system at UNISA. This will ensure the best sound quality during the discussion. And we also are requesting you to kindly post your question on chat. Those questions will be attended to after the discussion. Professor Knobbe, I think it's time for me to let you go ahead with your presentation. The podium is yours.
Thank you very much, Professor Mokotong. May I ask whether you can see the screen that I have shared?
Yes, I can see it. Student, can you confirm maybe by dropping a liner on the chat? Yes, they are.
Great, thank you for that. All right, welcome students.
Thank you, students.
Thank you, welcome from my side, all our students. We are glad that you could make it to attend at such short notice. Things have been rather a little bit on the hectic side here at UNISA as from the beginning of this year, but at least we are slowly getting into our stride now, and this will be the first of a series of discussion classes. And in this one, I am going to make a couple of introductory remarks on delict, on how to approach the law of delict as a topic in general. And then we are going to focus on the 2 topics, which are the topics for your first assignment, namely the elements of conduct and wrongfulness. Now, I may just mention again that because attendance figures are not so high, and because it's our practice in any case, we are going to post a recording of this discussion class. We're going to make it available, so you will be able to view it at your leisure later, and all the other students who were unable to join today will be able to do so as well. All right, so let's start with the law of delict in general. You will see if you look at the prescribed textbook that your first chapter is an introductory chapter, and there are a couple of topics in there, like there's a differentiation between breach of contract and delict, and also crime and delict, because there are also certain similarities, and that's the reason why you are told what the differences are, also what the similarities are. You also get a part on the historical development of delictual actions in South Africa. But here it is very important to have a look at your study guide, and you will see that the entire historical development as discussed in your textbook is not prescribed material for you. Just a certain part is prescribed for that. So it's very important that whereas the textbook contains your main material that you need to study, understand, memorize, and so on, it is important to always keep your study guide at hand, because in the various study units you will get directions as to what parts of the textbook are really prescribed and what parts you may only read, and later on in the module there will be even parts that you can leave out completely. Okay, the introductory part of the textbook also contains a section on the Constitution and the Law of Delict, and that is very important. So all of those things you have probably already read, but you will have noted that for the first assignment, this introductory chapter does not really come into play. We will test this in the third assignment, which has not been posted yet. It will be posted and made available later. And the other thing is, when we make things available on the system, we will always put out announcements to inform you of that. So please always keep an eye on your announcements. That's where you will be kept up to date. All right, I'm going to scroll down a little bit. First thing that we need to be very aware of in this module is we have a generalizing approach to the law of delict in South African law. That means that we work with general principles of liability. And in particular, delict or a delict consists of 5 elements, and they are the following: conduct, wrongfulness, fault, causation, and damage. Now, the implications of that is, if you are a plaintiff in a delict case, in other words, if you are the person who suffered a delict at the hands of somebody else and you want to institute a delictual action against the alleged wrongdoer, it means that you need to establish all 5 of those elements before you can succeed with your claim. Now, in practice, this does not necessarily mean that you will furnish proof of all 5 of those elements in every given case, because often the defendant will agree that some of those things were present, but he will contest others. So that is the reason why certain delict cases do not contain a discussion of all 5 elements. Usually you will find there is a discussion on wrongfulness or perhaps negligence, and you may know that negligence is a form of fault, so that means there will be a discussion of wrongfulness and fault. Sometimes only negligence, sometimes causation. It depends on what has been raised by the parties. But in principle, all 5 of those elements must be established by the plaintiff. Okay, so there I just want to make you aware of the fact that as you study delict, you must always think of what will the plaintiff need to do and what will the defendant need to do. Now, I've already covered what the plaintiff must do. The plaintiff must, in principle, establish all 5 elements. Okay, subject to what I have now just said, that some of those may not be contested, and then it's not necessary to bring definite proof about them. All right. What must the defendant do? The defendant's task is to eliminate just one of those elements. Because if you think of it, if all 5 elements are needed to constitute a delict, And the defendant can actually shoot down one of those elements and give proof to the court, to the satisfaction of the court, that that element is not present, then the defendant can walk free. Because that would mean that the plaintiff has not actually established that there really was a delict. So plaintiff, in principle, must prove 5 elements. Defendant, in principle, must eliminate just one element. But obviously, often the defendant will target more than one element and try to disprove them, because the defendant never knows in advance what the court is going to agree with. So the defendant will probably say, well, we are going to prove that there was no wrongfulness, and if we were wrong with that, we are in any case going to prove that there was no fault either. And if they can be successful with one of them, the defendant can walk free. Okay, so in respect of each element of delictual liability, you must be able to do the following. Use the definitions, tests, and criteria. What do we mean by that? I think let's just keep that in mind, and once I get to conduct, then it will become very clear exactly what I mean by that. So remember now, you're going to use definitions, tests, and criteria in respect of each element. You're also going to use requirements, right? And then you are going to substantiate with reference to authority. Now, authority really is case law in our module, because in the law of delict, there is not a lot of statutory law. There aren't many acts that you need to take note of. In the case of contributory fault, there is an important act, an important statute that you need to know, a piece of legislation. But in general, you are not going to learn of many pieces of legislation in this module. Most of the law of delict is based on the common law, and the courts interpret and apply the common law, and that's why case law is going to be the main source of authority. So if you mention a requirement or a criterion or a test, one of those things higher up on the page, and you need to substantiate, it would mean that you are going to refer us to case law. You're going to cite case names, and if necessary, tell us briefly what was decided in those cases. There are no prescribed cases in this module, but all the cases that are discussed in the main text of your textbook are prescribed in the sense that you must be able to mention their names, to cite their names, and to tell us briefly what is told in the textbook about those cases. So we make it a little bit easier for you in that respect. Then you will see I also mentioned their academic opinions. So academic opinions, not so much authority in the sense of if an academic has written something about delict that everybody will listen to that, but it has value to persuade. So if we think a case is wrong, we will tell you that. But you will still need to cite the case as standing authority and then add that, well, the academics Neethling and Potgieter do not agree with this case for the following reasons. Or if there is perhaps an empty space where there is not a specific case that tells us what the position should be, again, then the opinion of academics would be important. So as long as you have the hierarchy there, case law first, academic opinion second. Okay, we've covered that. So let's proceed to the element of conduct. That's the first topic that you can get questions on in your first assignment. And the first assignment, by the way, as you may have seen already, consists of MCQs. You get all your instructions as you log onto the assignment. You must do the entire assignment and submit it, and then you can also get a second attempt if you want to do a second attempt. Now, let's look at conduct. So you will remember that I said that you must always look at definitions, tests, and criteria. So let's illustrate this now, looking at the element of conduct. Now, the element of conduct can also be referred to as an act. So in other words, an act of a person is conduct. That you must not confuse with an act in the sense of a piece of legislation, like the Apportionment of Damages Act. Okay, but if we talk about an act, somebody damages something else, or somebody says something that injures another person's good name or another person's feelings. Those are acts. Those are forms of conduct. Now let's look at the definition of conduct, which we find in our prescribed textbook. In the prescribed textbook, you will find the following definition, and that is that conduct may be defined as voluntary human act or omission. Okay. Now, if you look at the textbook and you look at the chapter on conduct, then you will see that the various parts of that definition, in other words, that it must be voluntary, that it must be human, that it must be an act or omission, that those become specific paragraphs in your textbook that you get information on. So this shows how important the definition is. Why do we say you must look at definitions and tests? Because in the case of some elements, you are going to get a definition, as here in the form of conduct. And this definition, also functions as a test. So if you have behavior of a person that complies with this definition, you have actually tested that it actually is conduct for the purposes of the law of delict. But if you go to some of the other elements, like for instance wrongfulness, you will find that the definition itself may not be sufficient to establish whether wrongfulness is present or not. And particularly when you get to fault and specifically negligence, there you will get a specific test for negligence, the reasonable person test, which you will apply to a given set of facts to determine whether negligence is present or not. So those are the tools that you are going to apply to solve certain problems. The tests, the definitions, the criteria. For instance, we will say that the general criterion for wrongfulness is the boni mores. More about that later. All of those things are the tools that you use to solve legal problems in the law of delict as a field. Okay, so let's look at some of the smaller parts of that definition of conduct. Let's look at voluntary first. That's very important. What do we mean by voluntary? And you will find that there's a discussion about that in the textbook and quite a lot of information on that. Now, basically, voluntary means that the behavior of the person must have been susceptible to control of the will of that person. What do we mean by that? The behavior of that person must be susceptible to control of his or her will. That actually means that the person must have been able to decide at that stage whether he was going to do or not do that specific something that he did. All right, so it must have been susceptible to control by his will. It does not mean that he must have, or she, sorry, every time that I refer to he, I am implying she as well. It does not mean that the person must have willed the conduct. It only means that the conduct must be under the control of the person's will. So what's the difference there? To get to that, we must actually look at intention, which is one of the forms of fault. So we're jumping ahead a little bit. This will make more sense to you later on. But if we look at intention, the definition of intention is somebody must will a certain result and know that it is wrongful to do so. So if you will a certain result, it means that you wish that result to eventuate, to happen, to materialize. If you will something, it means you want it to happen. Okay. Voluntary does not necessarily mean that. It only means that you must have been capable to decide by applying your will at that stage. So for instance, say now somebody is sitting in the control tower at the airport, okay? And the aeroplanes are coming in for landing and others are taking off. And that person must regulate the traffic at that airport to ensure that everything is safe. Say now that person falls asleep, all right? And there is an accident. The question is now, was that action of not regulating the traffic correctly, was that voluntary or not? Now, obviously, it was not willed, because, I mean, no person in his right mind would have willed the aeroplanes to be involved in a crash, in an accident, not so. So in that sense, it was not willed. But could the person have decided to stay awake or to fall asleep? Yes, the person could. So in that sense, it was voluntary. Okay. Obviously, say now the person has a fainting fit for some reason or another. Say now the person has some kind of illness that he or she is not aware of, and all of a sudden the person suffers a blackout. Over that, the person has no control by his will. So if then the person fails to indicate to the aeroplanes exactly who must take off, who must land, and there is a crash, then that would not have been voluntary conduct, because the person was unable at that stage to behave in the way that he or she wanted. So that's what voluntary means. And voluntary immediately ties into the next topic there on the page, automatism. But that is seen from the side of the defendant. So automatism is a defense that that can actually make the defendant go free. If you succeed with proving automatism, it would mean that there can't be any act, because the element, that quality of voluntariness is absent. Automatism means that the behavior of the person was automatic, like that of a machine. So in other words, it was not susceptible to control of the will, it was not voluntary, and therefore there is no conduct if you can prove automatism. So exactly when you will have automatism is explained in detail in the textbook. I'm not going to go into the various qualities that can make you be in a state of automatism at a given moment. They are all listed and discussed in detail for you in the textbook. But be aware that that a alleged wrongdoer can be in a condition called automatism. That will exclude voluntariness, and that will therefore exclude the element of conduct. Okay. Next element there, or the next facet or quality or subsection of the definition of conduct is that it could be a comissio or an omissio. Now, what do we mean by that? A comissio is doing something actively. So in other words, you take a hammer and you hit something with it. That's a comissio. Or you open your mouth and you say something that is insulting to another person. That's a comissio. You go out and you actively damage somebody else's property. That is a comissio. An omissio, on the other hand, is omitting to do something, failing to do something. So our example of the person who sat in the in the control tower at the airport who failed to indicate to a given plane that it had to take off at a certain time or had to land at a certain time, that would be an omission. But it still complies as conduct. Even though the person, so to speak, did nothing, he did not act actively, that was still an act for the purposes of the law of delict. It was still conduct because omissio is still voluntary, it's still human, and it's one of the forms that conduct can take. All right, so we can also speak of a positive conduct and negative conduct. Positive in the sense that you actively do something, negative in the sense that you fail to do something, you do not do something. All right. So again, later on when you get to negligence, you may be confusing omission and negligence. And again, this will make more sense later. So come back later and refer to this information again when you get to negligence. Negligence is a form of fault, and negligence is basically not to act in the way that a reasonable person would have acted in. So in other words, not taking the steps of care that a reasonable person would have taken in the same scenario. So that sounds a little bit the same. It sounds as if you are omitting to do something. But you can have an omission that is intentional. And remember, intention and negligence are the two forms of fault. So let me give you an example. Say now the person in that watchtower is a crazy person. I'm saying he's a crazy person because he's a very vindictive person, and he's not, I don't mean that he has a mental illness or something like that. I'm just saying the words in the sense of this person is not somebody who you would like to have near you, because this is a person with a vindictive mind. Say that person wants the planes to crash. Now that's unthinkable, but just for the sake of argument, let's say he wants to do so. If he then does not give the correct instructions to the pilots of the aeroplanes, he does not send out the correct messages at the correct time, then he is performing an omission in the sense that he is not doing something actively, but rather omitting to do something. But he is doing so intentionally. He knows that it is wrong to do so, and he is directing his will at that result. So that is a willed omission. And remember, an omission need not be willed, but it can be willed. And this is an example of one. So that's a scenario where you have an intentional omission. Let's give you another example. Say now you walk next to a river and you see somebody drowning, all right? And for some reason or another, you decide you're not going to try and save that person. Perhaps you cannot swim very well. Perhaps you have a severe illness in your body, which will not take to water very well. Perhaps you know that there are crocodiles in the river, or whatever the reason, but you decide not to go to the assistance of that person. That is an omission in the sense that you are failing to do something active, but it is intentional in the sense that you decide not to do so, and you may know that it is wrong to do so depending on the facts. On the other hand, you can have a negligent omission. So in other words, you just forget to do something and then you don't do it. So remember, negligence and omission, not quite the same thing. Negligence, a form of fault; omission, a form of conduct. Okay, but as I said, all of this will be much clearer later on when you get to fault. So let's go a little bit further. And that is the element of wrongfulness. Okay, so again, If you're looking at wrongfulness, which is your next chapter in your textbook, viewed from the needs of the plaintiff, the following are key aspects that you need to look at. The first is tests or criteria. We've always been hammering on this. So the basic test for wrongfulness is the so-called boni mores test, which you see there. So boni mores is a Latin word, old phrase that we get from Roman law, and these days we translate that as the legal convictions of the community. So that's the basic test for wrongfulness. But there are a couple of things that one must bear in mind here. If we say that the legal convictions of the community, that is the basic test or criterion of wrongfulness, that does not mean that if a court needs to decide whether wrongfulness was present or not, that the judge actually goes around and does an opinion poll to find out what the community says. That's not the way it works. So in one case, the Schultz versus Butt case, the court said that what we mean by the legal convictions of the community is the convictions of the community as given shape by the legal policy makers in the community. And those are people like the legislators and the judges. They will interpret the boni mores for us. But what is important is that boni mores must always be in touch with what the community in South Africa would want. Now, obviously, that's a bit vague because the community is composed of different segments. There are different population groups, etc., etc. But as I say, it would be interpreted by the legal policy makers, the judges and the legislature. And the other thing that is extremely important here is that we now have a constitution, and the constitution is the highest of all law in South Africa. Very important is that whatever the boni mores are going to be in the law of delict must be in accordance with the values of the Constitution. So the constitutional values, and specifically the Bill of Rights, are really the most important factors that influence what the boni mores are going to be at this stage. So to find out what the boni mores are, in a given instance, we are going to have to read old cases and later ones, and we are going to have to view everything through the spectacles of the Constitution and the values and the rights protected in the Constitution. Now, obviously, the boni mores is a very vague criterion, and therefore it is not directly applied in all delict cases to determine what wrongfulness is, whether wrongfulness is present in a given case or not. So we really have other more practical applications that have crystallized out of the boni mores. They are not in conflict with the boni mores. They actually give effect to the boni mores, but they are more specific, more concrete, and they are easier to apply in given instances. And two of those criteria or norms are the following, and you find them listed there. First one is infringement of rights. Second one is a breach of a legal duty. So normally the court will not say, is this according to the boni mores or not? That will normally not be the first step, even though that is the basic criterion. The court will normally ask, has a right been infringed here? Or was there a breach of a legal duty here? So those two are, in a sense, in the alternative. You will normally not use both of them in the same case. So how does one know when are you going to look at infringement of a right and when are you going to look at the breach of a legal duty? So it depends on the form of that the delict takes. Definitely, what is very important is what kind of conduct are you dealing with. So remember, we have two broad classes of conduct. We just looked at that just a couple of minutes ago. One is a commission, the other one is an omission. Now, a commission, an active act, going out and actively doing something, that is easier to determine the wrongfulness than an omission. Because in the case of an omission, if one used normal speech, one would say, okay, but that person didn't do anything, you see. So, but in the case of a commission, well, you saw that person going out, taking the hammer and hitting something and breaking something with it. Or you could hear the person saying things that were hurtful and insulting to somebody else. So in the case of a commission, we normally work with the infringement of rights. But it is so straightforward that the courts normally don't spend too much time on it. Because if by a commission you harm somebody's property or his person, and his person can include things like his good name and his privacy and personality interests like those. So they don't need to refer only to his body as a physical entity. But when you have an act that by way of commission injures person or property, then that normally is prima facie wrongful. So that would mean that the court is not going to spend so much time to determine wrongfulness in those cases, unless the defendant can bring a defense showing that this really was lawful, not wrongful. So in those instances, we won't find long discussions of the element of wrongfulness in those cases. But when we are dealing with an omission, which is the other form of conduct, then it is more difficult to determine whether wrongfulness is present or not. And in that instance, we are usually going to work with the breach of a legal duty. So the court will ask, was there a legal duty on the defendant, the person we want to hold liable? Was there a legal duty on that person by positive conduct to prevent the causing of harm towards somebody else? And if there was a legal duty like that, and by omitting to do anything, the person actually breached that legal duty, then we will say that omission is wrongful. So that's how a legal duty comes into conduct in the form of an omission. So where does the legal duty come from? It comes from the boni mores. It comes from the legal convictions of the community. So the legal convictions of the community as the upper norm, the ultimate norm of dealing, will determine for us whether in a given instance there is a legal duty on a person to act to prevent harm. All right. But we won't necessarily in all instances have to refer directly to the boni mores, because certain instances have crystallized and there have been many cases about them. So we know these are certain categories where we have a breach or where we will have a legal duty on the person to prevent harm. And those categories are very important for you to study, and you will find that there's a whole list of them in your textbook. One is where you have prior positive conduct. The other one is where you have control over a dangerous object. The other one will be where there are certain relationships between the plaintiff and the defendant. The other one will be where there is an interplay of different factors that all work together to place the legal duty on that person. Now, the one that we love to ask in the exam is the one that deals with prior conduct, because that was actually the classic first example where liability for an omission was really recognized by our courts. And there's a whole long line of very important delete cases that established this whole principle. So there's a whole history of cases that determined that, and you will see that in the textbook. And the turning point was the Minister van Polisie versus Ewels case the case was still the case was still delivered in Afrikaans. That was an old case, but we have translated all the important parts of the judgment for you into English. So if you have trouble with Afrikaans, don't worry, you'll find the translated bits in your textbook. And after that, there have been other cases. There was the Carmichael case, which was actually a constitutional court case. So omission is a very important topic. Not so much omission under the first chapter, conduct, but when we get to this chapter, namely when you must determine whether the omission was wrongful or not. That is a very important topic, and it needs to be studied in a lot of depth. So I've just made a couple of introductory remarks, but you will find there's a lot of material about this in your textbook. You need to study that in depth, please. Okay, so as we say, you see there are four. If you look back at the screen again, we say tests, criteria. We spoke about the boni mores. We spoke briefly about infringement of rights. We also spoke about the breach of a legal duty. And just to recap, legal duty is the one that we are going to use where conduct takes the form of the omission, because that's more difficult. It's less straightforward. There's also another instance, and that also comes much later in the module. There is something like that is known as the causing of pure economic loss. I'm not going to define it now, but when you have the causing of pure economic loss, you will also usually determine the wrongfulness of that using the breach of a legal duty. All right. Then the next thing there, you see there, the next heading there is reasonableness of holding a defendant liable. Now, this is a newer approach that has developed in our case law. And in the beginning, it was given as an alternative to all that has come before. So in other words, the boni mores, the infringement of rights, the breach of a legal duty, the courts actually said that this approach, the reasonableness of holding the defendant liable, has actually superseded those other criteria. So it comes in the place of them. And that has met with a lot of criticism, especially from your textbook writers, because they were also always very happy with the boni mores, the infringement of rights, and the breach of a legal duty. And they were not in favor of this new approach that wrongfulness consists in the reasonableness of holding a defendant liable. So what we expect of you there is not to know this in a lot of detail. You must just know it in broad terms, what this approach entails. And then you must have an opinion as to whether this approach supersedes the others, the boni mores and the infringement of rights and the breach of legal duty, or whether it can actually be reconciled with those others. And there you will see that there is another heading there, and that is the conciliatory approach. And that is really the one that I personally prefer, and that is to find a way in which the reasonableness of holding a defendant liable can be reconciled with those older criteria, namely the boni mores, the infringement of rights, and the breach of a legal duty. Right. So that is really where I think the true position is. Unfortunately, there have been a number of important cases that has followed an approach in which they reconcile this new approach and the older approaches. And one of the most important cases was the Loureiro case. And we'll see that it is discussed in your textbook. All right, now I'm going to move on a little bit. Now there, in respect of the element of wrongfulness, viewed from the needs of the defendant, the following are key aspects. Remember, we said that all of these elements you must always view from the side of the plaintiff and then also from the side of the defendant. Now, the defendant is obviously going to try to raise a defense. Now, we have many defenses in the law of delict. We already encountered one when we discussed conduct, and the defense that we encountered there was called automatism. So automatism is a defense that can exclude the element of conduct. Okay. Now there are other defenses which can exclude wrongfulness. Now those defenses, specifically the ones that exclude wrongfulness, not the others, so in other words, not automatism and not others that you will find discussed in the other chapters, but the defenses discussed in this chapter on wrongfulness are collectively known as grounds of justification. So a ground of justification is a defense that excludes wrongfulness. So obviously, this is what you have to study if you want to advise a defendant in a delict case on how to eliminate a finding of wrongfulness against him or her. So again, what is important? Definitions, requirements, and differentiating. So you will find there's a long list of grounds of justification. There is, for instance, consent, there is private defense, there is necessity, there is provocation, and a couple of others. So in each instance, you are going to need to know the definition of that specific ground of justification. Then you are going to have to know the requirements, because each one of these grounds of justification has its own requirements, and those requirements must be met if the defendant is going to establish that that specific ground of justification is applicable to his or her case. So you need to know those requirements, you need to be able to apply them, and of course, as always, everything you need to be able to establish with reference to authority. So if there is a case that says a certain thing, you must be able to cite that case as authority. And then why do we say differentiate? We say that because sometimes one can get confused between some of these grounds of justification. And I'm going to illustrate that with just one example, and that is the example of private offense and necessity. So what is private offense? That is when a person, in order to ward off a wrongful attack against him or her, causes harm in a lawful manner to the attacker. Okay? So let's give an example. This is what is known in ordinary language as self-defense. So in other words, somebody attacks you. Say now you walk alone at night in the park and somebody attacks you with a knife. But you have your golf club with you because you're coming back from a round of golf. So you hit the person over the head with a golf club and you cause a lot of damage to him. Okay, he's injured because of what you did to him. Now, if he says that you committed a delict and that you were acting wrongfully, your defense, in other words, your ground of justification, would be private offense, because you will say, no, it is true, there was conduct on my part in the sense of a voluntary human act of omission, definitely, and I also caused harm to this guy, damage, yes, of course I did, but I did not act wrongfully because that person was already wrongfully attacking me and I was warding off the attack, and therefore the harm that I caused was not caused in a wrongful manner. That is what private offense means. The reason why we don't call it self-defense here in the law of delict is because you can also defend somebody else. So if I walk at night in a park and I see somebody attacking, say, a child or a woman or somebody who can't defend him or herself at that stage, and I defend that person and I cause harm to the attacker in the process, then that causing of harm was not wrongful, because again, I was warding off an unlawful attack. I was acting in private offense. Okay, now what is necessity? Necessity is where a person escapes from a state of necessity a state of danger that endangers this person, and in the process causes harm to an innocent third person. Okay? Now again, one can in necessity also protect somebody else. You need not protect yourself. But how does this work? So say now, for instance, you are on holiday on a tropical island and you see a tsunami coming towards you. And you see there's a motorbike there. And you've never been on a motorbike, but you think you will get it going. You get it going and you drive away as quickly as you can. And you drive to a hill where you are safe and the tsunami doesn't get to you. But in the process, you damage the motorbike. Say in the end you hit a tree or something and there's damage to the motorbike. Okay? And say now the owner was on a pleasure flight in a helicopter or something, so the tsunami also didn't get him, and now he gets back and he sees what his motorbike looks like, and he says, but you damaged my motorbike. I didn't give you permission for that. That was wrongful. I want to claim the damage to your motorbike from you. Then you would say, no, but I had to escape a dangerous situation that was threatening my life at that stage. And that is the reason why I caused harm to that person. And for that reason, it is not wrongful, it is actually lawful. So that would be an instance of necessity. And your conduct would then, in effect, be lawful, not wrongful. Now, the reason why I'm saying one needs to differentiate between these two is, let me give you the facts of State versus Goliath. That's an old criminal case, but it is very relevant to dealing. So what happened there was a strong person, let's call him A. And there was another person, let's call him B, and there was another person, let's call him C. Now, C was the victim in this instance. So A, the very strong guy, tells B, if you don't assist me to kill C, I'm going to kill you. So B is so fears for his life so much that he assists A to kill C. Right. Now, this was a criminal case. It was not a dealing case. So we must decide whether B's conduct was wrongful or not. This will be an instance of necessity, not private offense. Would you say there was an attack, a wrongful attack, from A's side towards B? In other words, when A said, if you don't help me, I'm going to kill you. Do you think that's an unlawful attack? Yes, it certainly is. So one could think that perhaps this was a case of private offense, because there was an unlawful attack on B, the defendant. But it is not private offense, because we must look at the person who is harmed by the defendant's conduct. And in this instance, it was not A, the attacker, that was harmed. It was C, the victim. It was an innocent third person that was harmed. So if we need to decide whether B acted wrongfully, B will have to rely on necessity, not private offense. Now, I'm going to give you another example. And folks, it looks to me as if we are going to go a little bit over the time, but I hope this is going to be valuable to you. Now, let's go back to conduct quickly again. Remember, we said that conduct must be a human act or omission. That means an animal cannot act for the purposes of the law of delict. But a person can use an animal as an instrument. So if I have a dog and I order my dog to bite you, for the purposes of the law of delict, I was the person who acted. The conduct was mine because I ordered the dog and I used the dog as an instrument to cause harm to you. So we're not going to try and hold the dog liable. We're going to hold me as the owner of the dog liable. So let's take the following example. We're walking in the park. I see you there. I've been hating you for a long time. I've got my very vicious attack dog with me, and I orders my dog to go and bite you. Okay? And now you are carrying your golf clubs with you because you are just coming back from a round of golf, and you hit my dog over the head, and you do so well that the dog is killed. Okay? Now you have caused harm to me, not so, because my dog is dead. So if I want to institute a delictual action against you, what offense, what ground of justification are you going to raise? You are going to raise private offense, because you are going to say, this guy was already attacking me in an unlawful manner. He was using his dog as an instrument to launch an unlawful attack against me. And yes, it's true, I caused harm to him by killing his dog. But that cannot be wrongful because I was acting in private offense. And the court will agree with you. But now let's change the facts a little bit. Say now I've got this very, very angry and very vicious dog. Now I go on vacation and I ask Professor Mokotong, please look after my dog for me. And you must every day take my dog for a walk as well. Now Professor Mokotong takes my dog for a walk, and she sees you there, and she's been hating you for a long time. And now Professor Mokotong and the dog now have a very good relationship. So she orders the dog to go and bite you, okay? And the dog is coming straight for you. But you've got your golf clubs, and you kill the dog, okay? Now, was there an unlawful attack on you? Obviously there was. Professor Mokotong, by ordering the dog to bite you, was obviously launching an unlawful attack on you. Okay, so there was an attack. But whose interests did you harm? Did you harm Professor Mokotong's interests? No, you didn't, because it's not her dog. The guy who suffers the damage is me, and I'm on holiday. So I'm an innocent third person, because my dog is now dead. So if I return from holiday and I want to institute an action, a delictual action against you, then what ground of justification are you going to raise? Private offense won't work because I did not attack you unlawfully, and you did not harm my interests. I am the third innocent person, and you harmed my interests. So in this instance, you will rely on necessity, not on private offense. Even though there was an attack on you, because that attack from Professor Mokotong's side constituted the state of necessity that you had to protect yourself from. So I hope that with these examples, I have pointed out to you that in a given set of facts, one can easily think ground of justification A is applicable, but it really is ground of justification B. And the only way to apply these grounds of justification correctly is by knowing the definitions, the requirements really well. So that is what I've been trying to bring to your attention. You really need to know exactly what the requirements for each one is. Otherwise, you are not going to be able to apply them correctly. That is the last sentence there on our screen, and that is you must know these things to be able to use. So in other words, the idea is not that you must know all of this information, just be able to recite it. The reason why you must really know all this information is so that if we give you a set of facts, like a story of somebody sitting in a control tower at the airport, or somebody taking a dog for a walk and then instructing the dog to attack somebody, when you are confronted by a set of facts like that, you must know the principles well enough, the definitions, the requirements, the criteria, the tests. You must know them well enough that without referring to your textbook or your case law, that you can apply them to those given facts. All right. I think that concludes everything that I wanted to say. So I'm afraid we're not going to have too much time for questions. I think, Professor Mokotong, can we perhaps allow some questions up till about A 11:15, and then I think we must end this session, please, if you agree with that.
I do, but luckily, we do not have questions. The only question that was raised by David, you addressed it in your discussion, and David also acknowledged that we don't have any questions at the present moment on chat. And so I would say it will be the end of the discussion. But before we really close, I'm not sure if there's anything that you'd like to say to the student. Oh, there's one here by Maria. It just came through. Let me go through it. Professor Knoble, in case where I walk my dog and I'm being attacked and then instruct my dog to attack my attacker, is there any defense that my attacker can rely on? I'm not sure if, can I repeat it, Prof. Knoble?
No, I think I have caught the question.
The question, okay.
Yeah, that is actually the first example that I gave, is it not?
Yeah, it is.
So the attacker, look, no. Okay, it depends who is instituting the action against whom, all right? So I think the student is saying, if I take my dog and somebody attacks me
in the park and someone else is A, walking the dog in the park, then B tries to attack A, then A instructs his dog to attack B.
Yes.
Yeah.
So the question is now, yeah, let's get back to the student and the attacker. Okay, so the student is walking her dog. Is that correct? Yeah. Okay. Somebody attacks her, and now she sends her dog to bite him.
Yes.
Okay. So that's the first scenario that I have dealt with, and that would mean, say now, okay, now the attacker kills the dog. Not so. Is that what I'm saying, or is that not part of the?
No, it's not part of the question.
Let me just see whether I can read that chat box. Where is that now? There.
Okay, she just said that then the attacker kills my dog.
Yeah. Well, that's the scenario that I've been covering. So you see what would happen then is a delict also always starts with somebody suffering harm. That's actually the last element of delict that we look at, damage or harm. But that's usually the thing that starts the whole litigation, not so. So somebody suffers harm for a reason that person is not happy with. So in other words, and it's harm that was caused by somebody else, by the conduct of somebody else. That's usually where it begins. So in this instance, the attacker killed the dog. So who is unhappy now? Not the attacker, but because the student's dog is dead. Okay, so the student will now be the plaintiff. Okay, but we must remember. So the attacker becomes the attacker becomes. Hang on, I'm confusing myself now.
No, don't confuse us. Relax.
Yeah, okay. The student is being attacked. She instructs a dog, and the dog goes for the attacker. Now the attacker kills the dog. Okay. The person who is going to be the plaintiff is the person whose dog is dead. That is the student. So she is going to say, look, I want you to pay for my dog. But then the attacker is going to say, no, but I was warding off an attack. Okay. Will that work or will that not work? That is now the question, because at that stage, the person who is now saying but the student attacked me with a dog was already attacking somebody else. So that is what makes things complicated. Okay. Now, in that, so the question is, can you, if you're already being, yeah, you know what? I think let us write a proper response to this, and then we can post this in the chat. That's going to be easier. Okay.
Okay.
Yeah, there I see there are many examples of automatism, not automation, automatism, and I see Professor Mokotong has already given some.
Yeah, that's nothing. That was the
Yeah.
last one, automatism. Yeah. Can we remind the student about
in
the
that case of student Marie's question, what happens there is she is using her dog really as a instrument to
It's an instrument, yes.
yeah, to protect herself against the attack of somebody else. So she is actually acting in private defense. Okay. So I think if the attacker then kills the dog, the attacker won't have a defense to rely on because that person already stepped outside the protection of the law by launching a wrongful attack. So I think that would be the answer in that instance.
Yes, actually, the student will have an action against that attacker for his dog or her dog.
Yes.
Yeah,
Yes.
for the loss
So
of that.
it would have been wrongful to kill the dog. It would have
Yeah.
been wrongful to kill the dog in that instance. And yeah, the student will have a delictual claim for the
she seems she's happy with the response because she says thank you, Professor Knobel.
Yes.
And we don't have another question. Let me see. Yeah, he's also even Hina also is thanking. Yeah, we don't have other questions, but maybe we should just reassure. Okay, regarding the assignment, will the two attempts questions differ? I'm not sure where Ivana is referring to when he says two attempts. Ivana, we're not clear. I'm not sure if you could just post something just for clarity. Are you referring to the attempts to answer the question, the assignment? I'm not sure, Prof. Do you understand, Ivana?
Yeah, I think what happens there is, like if you are the assignment one is going to look very much like our previous exams. So it's like an MCQ exam that you take, and we are going to allow 2 attempts. So that means once you have submitted the assignment, you can also submit another attempt. And if you answer it differently than the first one, I mean, that would be the whole point, because why would you submit 2 attempts that are actually quite exactly the same? That would make no sense. So if you submit 2 the other thing is, of course, the questions are going to be randomized as well. So if you take a second attempt, you're not going to get the same questions as the first time. It's going to be a different assignment, but on the same topics. So I suppose perhaps that's the answer. The other one is, so in other words, your answers are also going to differ. So the 2 attempts are going to differ completely in respect of the questions and the answers. What will happen then is the system will select the one with the highest score, and that will count toward your year mark. I hope I've answered the question.
Yeah, you did. Prof, can we inform the student about the due date just to remind them? Yes. Taking into account the media presentation that indicated that there was an extension. Can you just clarify to the student so that they know where they stand?
Yes, students, we have seen in the media, we have seen that Apparently, UNISA is going to give an extension for due dates for the first assignments. We have not seen a formal communication from our superiors on that yet. So unfortunately, we can't give you the real and final say on that now. So at this stage, please still regard the due date that we have given as the one that is standing. If we get a communication from the UNISA authorities that changes that, we will immediately inform you by way of an announcement. So please keep an eye on your announcements. That's where anything official will come from. But at the moment, we can't tell you whether this new extension given by UNISA will affect our due date specifically or not. So I think, yeah, that's our response at this stage.
Maria is saying, will there be an exam or is it only the assignment? As your email to me indicates that assignment 1 and 3 will each count 50% toward the year mark.
Yes.
Can you clarify that?
The year mark is only a small percentage of your end of year mark. So yes, there will be an exam, and the year mark is just that part that is added to the exam mark to give your final mark. The other thing that's important to point out at this stage, and look, we are a little bit behind with all our communications, but we will set this right. The exam this semester will not be in the form of multiple choice questions. So you have 2 assignments that are multiple choice questions, and they contribute to your year mark. Then we have another assignment that does not contribute to your year mark, and that is a written assignment. So the written assignment is going to give you an exercise on how to write a response to a delictual question out in a paragraph. And that is the form that the exam is going to take. There may be some multiple choice questions in the exam. We have not been informed about that yet, but the exam will definitely not consist only of MCQs, as was the case in the recent past. All right.
Prof, there's one
Yes.
from Simpi, where Simpi was saying that they're having challenges with my module because it's not working efficiently. And he also suspected that it could be the reason why most students were unable to can join in this morning. And so he's asking if they can get the announcement on my live emails account. I'm not sure if we can do that.
Yeah.
That's the challenge, Simpi. I'm not sure, Prof, can you address that?
Yes, yes. The only thing I can say is my modules is at this stage causing lots of trouble to us as lecturers as well. Because what happened was UNISA migrated from an old electronic platform to a new one. And that is why they are doing maintenance work on my modules every now and again. Now, unfortunately, we have no control over how the announcements get sent to you. So at this stage, we can't do anything about it. The only thing I can request is please look at your announcements as often, as frequently as possible. Hopefully, the teething problems that we have with my modules at the moment will be ironed out, and hopefully my modules will become more stable as the time go by. But at this stage, we have no way of sending emails in bulk to all the students. We can only reply to individual emails. We can't send out emails in bulk to all our enrolled students. So unfortunately, we can't comply with that.
Yeah, she understands. She responded. So far, Prof, we don't have any other questions or comments. I think it brings us to the end of the discussion. I would like to thank you for your effective discussion. I really believe that our students will excel in their response to assignment 1. And students, should you experience any problems, please feel free to drop us an email. We will definitely respond to your emails, and we would like to wish you well with your studies. And please be safe, because Corona is still out there, and we need you as our student, because remember, you are the future generation of the legal field. Thank you so much for attending. Thank you very much, Professor Knobel, for the discussion, and we'll look forward to other discussions in the future. Thank you, student. Best wishes. Bye-bye.
Thank you very much. Goodbye.